because what is expedient now will haunt you for the rest of your life. You can never escape from your conscience. So the only way you can live comfortably in your role is to distance yourself from all these temporary pressures and interests and deal with the only permanent part of your decision, your conscience. It's the decision I'm making based on my honest understanding of the evidence and interpretation of the law. Does it sit well with my conscience? Once I make that decision, it does not matter whether it is taken kindly or criticized. That is irrelevant. It does not matter at all.
Thank you. Friends, we are concluding. I'm concluding this remark that a judgment should fairly, clearly, and accurately state the significant facts, relevant rules of law, and demonstrate by its analysis the reasonableness of its conclusion. Human right. I thank you for being for being a good audience. Another hand clap for them. Thank you.
My lords, I invite you to give a thunderous hand clap to the chair for steering us so well. Thank you so much, my lord chair and the entire panel. My lords, we've been seated for so long. We have the FAB Wellness team in the house. I invite you to stand up and we do some exercise, and thereafter shall be able to see what is coming up next. Yes, we have earned ourselves lunch, but after this, we shall be, I'll make one more announcement, then we shall depart for lunch.
Good afternoon. I greet you, my lords. I think we need to agree that judicial wellness needs no litigation, needs no judicature. I think we all agree that we need it. And I think that's why it was chosen as a theme for this engagement since yesterday and today. My name's Patrick Gerenge. I'm the CEO at FAB Wellness. I have with my team here, Lina and Andrew. So without much ado, we're just going to take you through a few stretches to just wake up the muscles and so that you can go have your lunch when you're fully awake. Thank you. So if you are near a chair, please just push it back a bit. You know, we are made of rhythm. From the heartbeat, it's rhythmic. The way we walk, 1, 2, 3, it's rhythmic. So we are just going to enhance that. So so just move the seat a bit. If it's a rolling one, be careful. If it's a rolling one, because I would want us to sit. Let's sit. And let's stand. Let's sit. Let's stand. 2 more times. 1 more time. Last time down. Last time up. Last time up. All right, let's take a seat. Let's take a seat. Make sure where you are, your hands are free. So, that's what. Arms here. Now give me a right click, left click, right stump, left stump, right click, left, right, left, right, left, right, left, right, left, stamp, stamp. Let's go again. Come on, come on, come on, come on. Hey, hey. 2 more times. Hey, come on, come on. What a rhythm. Let's go, come on. Hey, hey, hey. All right, now this time we're going to go the other way around. Left, right, left, right. Let's go left. Hey, come on, come on. Let's go. Uh-huh, uh-huh. Hey, 2 more times. 1 more. Last time. Let's get it up. Let's get it up. Let's take it up. Let's take it up from here now. Now, arms here, arms there. Okay, right. Left. Right. Bring the right back. Left. Here. Arm there. Right. Both of the leg. Bring it back. Left. Back. Right. Back. Left. 2 more times. Let's go. 1 more. Rhythm, rhythm, rhythm. 1 more time. Last time. I can see some people have 2 left feet. Don't blame yourself. Don't blame yourself. That's why we are here. So breathe in, breathe in, breathe in. And out. Sorry, fresh. In. And out. In. Last time I hold it up for 5, 4, 3. So bring it down. Let's stretch our neck. Down here. Hold it down. Change to your left side. Both hands here. Put it down. Don't pull too hard. You need your neck. Arms down. Throw your head back. Don't fall back. Bring it back up. Now rotate slowly in one direction. Change direction. And stop. Hands here. Give me a brrr. 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 Hands here. Leg. Clap like in the parliament. Down. Faster. Faster. The fastest. 1, 2, 3, 4, 5. I thank you. Give yourself a big clap. Thank you, guys. See you next time. Thank you.
Thank you so much, Well Fabness. Let's give them a befitting hand clap. Thank you so much. My lords, allow me to invite our worship Kaba Singuzi. Okay. I've been guided that we have another session before we go for lunch.
Colleagues, good afternoon. It will be a brief one. The presenter has a flight to take. Okay, so I beg your indulgence. Okay, allow me invite Justice Wanjara, our guest speaker from the Supreme Court of Kenya. Yes, thank you. My Lord Justice Wanjara is a judge of the Supreme Court of Kenya, having been appointed in 2011. The CV is about 5 pages, and if I go through the whole of it, it'll be starting between our lunch and even his flight itself. So allow me, give him the opportunity to present on the experience or perspectives of Kenya in election petitions. Justice Wanjara, smoking without G. Thank you.
Thank you very much, my Lord Chair. My Lord Chair, with your kind permission, before my 15 minutes start running and before I eat too much into the lunch time, allow me to, I know that the Lord Chief Justice was yesterday felicitated, but coming from Kenya, allow me to add the Kenyan voice of congratulating in absentia His Lordship, the Chief Justice, upon his appointment to that position. Allow me also, my Lord Chair, to congratulate the CJ Emeritus and friend of mine, Lord Chief Justice Emeritus Wing, for his successful retirement. Because we also know that retirement may be either successful or unsuccessful. But for my lordship, my lord, his has been successful. Let me also thank you, my lord, for inviting me to this session, just as you did to the last session in December. Because of you, I've had the privilege of coming to Uganda twice in a very short period. Thank you very much. And finally, allow me also, my Lord Chair, to congratulate the Principal Judge upon her appointment. And so, having done that, let me go quickly into what I'm supposed to do. I'm supposed to address judgment writing in election petitions. I have had, I don't know what to say, what to call it, the privilege. I've had both the privilege and the misfortune of sitting upon the 4 presidential election petitions in Kenya since the year 2013. Privilege because it's a rare opportunity to determine who ultimately becomes the president of a country. But misfortune because that is where judicial wellness now comes in. And I had my colleagues, and they have spoken so well. What do you do? Because by the time you finish, you are completely, you are completely down. In terms of the presidential election petitions and other election petitions in Kenya, it's not just a question of emotion. It's a life and death matter in Kenya. If there was a situation where judicial wellness is called for, it is the determination of an election petition, more so a presidential election petition. And I've gone through all those motions. I have seen it all. And so I thank God that I'm still here to talk about a presidential election petition judgment writing and judgment writing in other election petitions. So please join me in clapping for the Lord Almighty. Now, yesterday, His Excellency the President, in his speech, underscored the importance of the judiciary for a democracy. The same point was made by His Lordship, the Honorable Chief Justice, that the judiciary is an important and critical institution in anchoring our fragile democracies. In all aspects of judgment making, or in all aspects of determination, all disputes across the border. When it comes to judgment writing in election petitions, that becomes critical in anchoring our democracy across the region, because across the region, our democracies are still fragile experiments. And therefore, what we're talking about this afternoon is not just a mechanical process or exercise. It goes to the very heart of a contribution of a judicial officer to a fragile democracy. The history of election petitions in this region is clear, and mine is a perspective from Kenya, whether it is wrong or right, but just look at it from that perspective. If there is any best practice you may want to emulate, that is for the judiciary here in Uganda. But it's just to tell you how we do our things. And I must say, I've really enjoyed the two panels that talked about case management, and then my colleagues who have just spoken before me. I'm learning so much, which I will also take back home. I've learned about judicial foreplay, for example, and I will also take that back home. As we continue writing judgments, both at the High Court level, at the Court of Appeal level, and at the Supreme Court level, what we are also doing is to create sustainable jurisprudence that will make future controversies easily resolvable, because we need to create sustainable jurisprudence when it comes to certain issues that arise from an election petition. Next slide. Yes. Now let me address the form of a judgment. And what I'm saying is there's nothing new really. This is what we do on a day-to-day basis. It's difficult because I'm addressing colleagues on a topic which they utilize every other day. Because if we were not judgment writers, then we wouldn't be judges. And so what I'm saying really is nothing miraculous, it's just ordinary. But we may pick a few aspects that we can highlight in our individual work. So at the appellate level, both Court of Appeal and Supreme Court, the courts there sit in benches, and I believe that the same happens here. The Court of Appeal in Kenya sits in panels of 3, while the Supreme Court sits in a panel of either 5 or 7. The Constitution caps the quorum of the Supreme Court at 5, because the entire court is composed of 7 justices. The Chief Justice, the Deputy Chief Justice, and 5 other judges. And we have operated that way, that ordinarily will sit as 5. But where a dispute is so heavy that the optics require, remember I'm saying the optics require that the full bench of 7 sits, then it shall be so. And we have operated as 7 until recently, when we lost our colleague, Mr. Justice Ibrahim. And maybe we could observe just half a minute silence in remembrance of our colleague. May the Lord rest his soul in eternal peace. Let's go back to that slide, please. And so, for courts that sit in panels, you could decide to come up with a composite judgment, just one judgment, especially if there is no dissent, and if there is a concurrence. But even where there's a dissent or a concurrence, you can come up to just one judgment, because the dissent and the concurring is part of the judgment from the Kenyan perspective. A composite judgment has its advantages because it creates certainty, clarity, and also develops jurisprudence. So that when you read a judgment that is won as a lawyer or as a judge of a superior court but law, where the judges of the Court of Appeal and the High Court in Kenya, for example, when they look at a binding judgment from the Supreme Court, they are better off dealing with a composite judgment, because then it will be easy for them to see where is the jurisprudence here, where is the ratio decedent here, what is the reasoning, because it's clear, it's clear and certain. But it also has its own disadvantages. We heard from the colleagues who have spoken that when you are sitting on an election petition, it is the court sometimes that is on trial. Nothing can be clearer and more certain than that in the Kenyan situation, especially as a Supreme Court. When we are determining a presidential election petition, the court is on trial and you are profiled. They will say, even if it's a composite judgment, we can see these 2 paragraphs must have come from Judge Isaac Lenaola. This is how he speaks and this is how he writes. So they say, why are they hiding in one judgment? Why can't they come out as men and women and just speak? So there is that suspicious anonymity. You are always saying these people, there is something they're hiding. That's why, and where there is no dissent, why is there no dissent? These people have been influenced. That's why they are hiding in one. That's a disadvantage. But there's also another disadvantage, because a composite judgment suppresses individual judicial creativity. Because the way I speak, the way I write is different from the way Judge Lenaola writes. And I want my persona to come out as a judge. At the High Court level, judges are in control. And I'm sure this happens in Uganda. It is the judge who is in control of everything, from case management throughout the judgment. So there is no problem. There will always be one judgment. But what is the advantage of a separate judgment, therefore? It is that judicial creativity that I've talked about, and freedom. When you retire, or for whatever reason you are no longer a judge of the Court of Appeal or Supreme Court, at the appellate level, how will your great-grandchildren decipher your imprint in those judgments? That is the beauty of a separate judgment. But I've told you, if the disadvantage is if you write separately, they say you see the way, you see how he's speaking, you see how he's writing, and then it also stunts jurisprudence. You don't know where. So where is the ratio here? What do I take from these separate pieces, beautiful essays? So that is that. But that is the form. It is for you, my colleagues, to decide at the appellate level whether you should go composite or whether you should go separate. Next slide. The nature of the judgment. Again, this is ordinary stuff. A judgment may be unanimous, may be a majority judgment, that may have a dissent, it may have a concurrence. At the appellate level, my experience tells me that you are better off with a unanimous judgment, not for the sake of it. Actually, strive if you can come up with a unanimous judgment. In terms of an election petition, you are better off being unanimous, whichever way you go. Whichever way you go. In 2013, that was the first presidential election petition, hotly contested election. We decided to affirm the election and dismissed the petition. And we were unanimous, thankfully, because we did not sit as 7 or 5. We sat as 6 because one of us had just been hounded out of office. And we were saying, what if there is a tie? You would imagine what would have happened. But it was unanimous, although it attracted lots of criticism, but that unanimity was a bulwark. At least it gave us a place for resting. A majority judgment is a good judgment, especially where there is a dissent. And come 2017, we had a majority judgment. We decided to nullify a presidential election petition. So it was a bench. Again, we sat 6, as fate would have it, because one of our colleagues fell sick just at the commencement of the petition, and then he was flown out of the country. So we were 6. That time it was 4-2. 4 for nullification, 2 for affirmation. And therefore you can see the 4 of us, out of the 4, it was me and Judge Lenaula and 2 others. And then we had 2. The 2 had 50% of the electorate supporting them, and the 4 also had 50% of the electorate supporting them. But that is how it is. It is a political process, but you can always come up with this. A dissent is an important part of a judgment, in my view, because some dissents have turned out to become majority decisions in the future. But again, these are just general principles with which we are familiar. Next slide. The audience, I had my colleagues here speak absolutely correctly, in my view, about the audience. When you are writing a judgment as a High Court judge, as a Court of Appeal judge, and as a Supreme Court judge, and therefore as a court, you must always have at your mind who your audience is. And that shapes the nature of your judgment. The first audience, we were told quite correctly, in my view, by CJ Emeritus Katurebe, are the parties, because they are the ones who brought that case before us. So that is your audience. Then there is the wider legal fraternity. We have the legal fraternity, the lawyers, the bar, and lawyers at large. Those are your audiences. Then we have the international community. We have other jurisdictions. What comes from here in Uganda will reverberate through Kenya, Tanzania, and all over, even in the wider Commonwealth and beyond. That is also an audience. And then we have, never to forget, our schools of law. Those are our catchment areas. That's where we came from. And then the audience that is unforgiving is the electorate. In 2017, there was an article after we nullified the presidential election. The New York Times came up with a big subheading saying, in Kenya, the voters, the electorate votes, but the judges decide. So you can imagine, even as far afield as the United States, so your audience is also the international community. What am I saying? When you are crafting a judgment, do not forget your audience. And definitely don't lose the electorate, because it is the electorate, when they read, they'll see, although we are not happy with this judgment, I think it was so well written, it is right, it addresses the problems. So always we must have in mind who our audiences are as we write. You are not writing an academic text. You are not writing a political treatise. You are not writing a poem. You are addressing those people who, as of necessity, must be interested in what comes out. And that's how we develop jurisprudence, because from these audiences, we may improve in our future rendition of our judgments. Next. Now we go to the content of a judgment, an election petition judgment at all levels. And since I have sat on the Supreme Court in its original jurisdiction, listening to the presidential election petition, I've also sat at that court in its appellate jurisdiction, entertaining appeals from the Court of Appeal, and therefore they would have come from the High Court. It is very clear that this, to me, is what should shape an election petition judgment. First, it must be clear and concise. We must avoid all this bluster. In my view, that's what we've done. And again, this is just a Kenyan perspective. My lesson is that from a Kenyan perspective, we have learned that a judgment must be clear and concise. Let's not go into uncharted waters. We have learned. And then it must be well structured. But how do you get a well structured judgment? You write a well structured judgment depending on how efficiently you have managed, an efficient case management process. And my colleagues who addressed that did it so clearly that if you have a good and efficient case management, it must of necessity lead to a well-structured judgment. Because if you manage your case badly, you will be addressing issues across the board. How did you identify your issues? So to which issue are these two paragraphs speaking? Must be well structured. And then it must be legally sound. From the High Court's point of view, we must, and we have been training our newly appointed judges to the High Court, that you must read and be astute in terms of the content of the law. What will the Court of Appeal take issue with? Is it the way you have assessed the evidence? Is it the way you have applied the law? So it must be legally sound, especially at the High Court level. You are, of course, determining a dispute, but it must be legally sound as not only to satisfy the electorate, but also to withstand an appellate process. It must be well reasoned. And again, this I'm picking from what has been stated by the panel. We have been told that we should disengage emotionally from the judgment. We must just stick to the issues, the evidence, and the law. It must be well reasoned. This is the lesson that we have learned for ourselves, that it's clear and concise, well structured, legally sound, and well reasoned. Next slide. Now the rendition. How are we rendering? And these are again strategies, again influenced by the case management, by the pre-trial or pre-hearing conferences, by how you have been collecting the evidence, by how you've been arranging and reading the pleadings. So always, in my view, again, the Kenyan way is that we start by stating the petitioner's case clearly. What is he or what is this man or woman complaining about? Why? What is he saying? And state it clearly, because if we don't state that case clearly, we will not be able to answer it clearly. So this should be, again, concise, but stated clearly, so that the electorate say, when this man went to court or woman, what was he complaining about? Why did he say that this election is not fair, was not free, was not verifiable? Those are the principles in our constitution. And then to follow it with the respondent's answer. How did the respondent, because this judgment is now speaking for itself. Let the judgment speak for itself. This was the respondent's answer. On this issue, this is the respondent's answer. And it goes on. But then what were the issues? Because then the issues we derive from the two cases. The pleadings. And in Kenya, what we do not go to court before we have identified the issues ourselves as a court. We read the pleadings, we identify the issues, then we go to the pre-hearing stage together with the parties. And before we allow them to speak, we say, in our view, looking at the pleadings, having read their affidavits in support of the pleadings, these are our issues. This is how we have identified with. And what we do, if you are a single judge at the High Court, you do that yourself. If you are an appellate court, you task one of your colleagues to do that, and then you debate among yourselves. Is this an issue worthy taking our time? So that's the way we do in Kenya. Then we present it to the parties in an open hearing. It's televised. And we ask from the petitioner's position, is there any other issue, or have we left out an issue you think we should not have left out? And the same question is thrown to the respondent. And they say, we are satisfied. What I find very interesting is that when it comes to issue identification and formulation, we have never been challenged. The lawyers will always say, no, we are happy with these issues. But if you throw it as an open-ended, as we try to do, then there will be issues of politics, there will be emotional issues, there will be all those things. So when you start writing your judgment, you do not know what you are addressing. Your judgment definitely will not be concise. And that's why I was happy to hear my colleagues who have spoken before me, time after time, emphasizing the question of issue identification. But in Kenya, we do it as a court, then we throw it at the parties or their lawyers. And then, of course, the applicable law. I've been hearing the exchanges. The applicable law, every election petition has its own legal regime. In Kenya, we have the constitution when it comes, especially the presidential election petition. Then we have the presidential election petition rules, the presidential election petition practice directions. That is the legal regime. Then, of course, we have precedent from both within and without. And from time to time, we also cite, we are persuaded by decisions from Uganda. So that is the legal regime. And at the High Court, you have to be always conscious of the applicable law. If you apply law that is not applicable to a petition, that is ground almost straightforward for you to be overturned. And so we need to know the applicable law. Then the assessment of evidence. Again, this is I'm just repeating, but I couldn't agree more with what was stated here, that assessment of evidence is important. Will you come up with a judgment that can be struck down at the appellate level on the basis, on grounds that the conclusions the judge arrived at are not supported by the evidence on record? I think, speaking to my colleagues at the High Court, that is something we have always told our High Court judges to avoid. Do not be struck down on grounds that your conclusions were not supported by the evidence. So even how you render your judgment, you see that you have analyzed and assessed the evidence. And then your findings and conclusions will then lead to a final decision. That's how, for us, we render. And if you look at the decisions of the Supreme Court, Court of Appeal, and the High Court, they follow this format. And they've been greatly influenced by the practice at the Supreme Court. Next slide. And then the strategy. Again, this goes to this. Is that place the one before? the previous one, or no, then the one that follows rendition. I think there is, yes, that one. The technology can also sabotage, as I'm saying. I think it's AI. Okay, let's see whether we can pick it up from here, because that strategy is important, and it also goes to some of the questions that were addressed at the case. Okay. Again, the strategy is let the pleadings speak for themselves. The way we manage time is that you should start arranging the judgment long before the arguments have been closed. Because already you have the petition, you have the affidavits in support, you have, I believe we may have some research assistance, so that by the time the petition has been filed, proactively start writing the judgment, start setting out what we call the pillars, so that by the time you start writing the judgment itself, you already have the pillars. Our law clerks will already have gone through the pleadings, and they will already have arranged the pillars. We do this, especially at the Supreme Court level, because the Constitution gives us only 14 days from the date of filing. We must hear and determine and render a judgment in 14 days. So talking of judicial wellness, what we go through in those 14 days, and then Kenyans become experts in the law. We become a country of 50 million legal experts who are discussing, and because the case is being streamed live, people pass judgment well before the Supreme Court has written the judgment. So the strategy is let the pleadings speak for themselves. Be in charge, I've already stated, of issue identification from the beginning. Admit evidence where you must, but you should also decline where you ought to decline. So it is how you navigate. At the Supreme Court level, in 2013, because of the times, we say you will put in your written submissions, you'll put in your case, you'll put in your affidavits. On the fourth day or fifth day, we go into hearing. When that time came, the petitioner introduced an 800-page affidavit, which this 800-page affidavit, when we had closed the pretrial or pre-hearing stages. And I think on hindsight, we ought not to have disallowed that, because it was then used later to really attack the Supreme Court. Because the petitioner then said, you see, they rejected 800 pages of evidence. How can you believe that judgment? When we looked at those 800 pages, it was just hot air. In 2022, you may have, for those of you who are following those theatrics and drama, there was social media and mainstream television, which was beaming hundreds of pockets of evidence in full pickups and canters. They say this is the evidence of the malpractice being taken to the Supreme Court. Lots of it. So when it came, we said, no, we will admit. You admit, but subject it to proper analysis. Sometimes you may be forced to admit, just so to maintain the legitimacy of your judgment. At the hearing, again, this is just matters of strategy. You have to interrogate counsel intelligently on behalf of the electorate. The questions you are asking counsel, you are asking on behalf of the electorate. You may ask them on the technicalities of the law, but when it comes to their allegations and counter, you have to put yourself in the feet of the electorate. You see, and when they go back, say, did you hear how That question nailed them, you know. It's so good. That's the time you legitimize the judgment. You are consciously or unconsciously representing the electorate. The electorate is not a party, but the electorate is the major party in an election petition. So you must interrogate counsel intelligently without engaging into ping-pongs. Just say one question, two questions, three questions, and you stop it at that. You are addressing the electorate. Is what this guy is alleging, is it true? For us, we always deliver a short version because of the time, 14 days. But of course, the judges of the High Court and Court of Appeal in Kenya have 6 months within which to deal with all this. When it comes to appeals from the Court of Appeal to the Supreme Court, the Constitution does not give a timeline. Neither does the Election Act. Neither do our presidential election. But in-house, we have said if the Court of Appeal has 6 months, why should we also take 6 months? We can't. Let us take at most 3 months. That's what we do. Next, then I don't know whether you also have this animal called the interveners. This is a very serious animal. We have busybodies in our country. They will come in as interested parties. They were never involved in the elections. They were just gallivanting. But when an election petition is filed, they say they want to be joined as interested parties. Then we have the amicus curiae. We have the amicus brief, and what value do you derive? How do we deal with interested parties? The Constitution, for example, makes our work a bit difficult because it says anybody can file an election petition challenging a presidential election. You do not have to have been a party. And we have actually been sitting on such. So what we did at the Supreme Court level, we said that we would not allow an application for joinder as an interested party. If you're that interested, file your own petition because the Constitution gives you that leeway. Why are you pig riding on other petitions? So we say no interested party. So at the interlocutory level, we dismiss that before we start the hearing. The amicus curiae, in 2013, we allowed them to appear and address us orally. But experience taught us that no, when it comes to these people, we must limit them to a written brief. And that brief, while reading, must convince us that they are bringing something novel, something new, they are helping the court beyond the arguments of the parties. And so we have also restricted the intervention of the amicus curiae. You file a written brief. If we admit you don't address us orally, but we will address your brief in a judgment, and we'll say what value we derived from the brief. Next,